Why is the machinery of justice in my cases down at the Family Court tinkered with? That is the question. It is not a matter of opinion whether they are or are not. They are. That has been pretty fairly observed the whole time, but this video is about the empirical proof of that. Now, I know. I am not special, and I am keenly aware of this. And the implication of that is that if this stuff is happening in my cases, it is almost certainly happening in others. That is also consistent with the dozens of conversations at this point that I've had with other litigants and other lawyers about their observations that the very same thing is going on. I just decided to prove it scientifically. So what am I talking about? Well, first you have to understand a little phenomenon down there at the Kenton Family Court. Okay, there's a whole bunch of levers, all kinds of levers of justice that the petty bureaucrats who control these things, outside the eyes of the presiding judge or anybody else, or the litigants for that matter. There's a whole bunch of levers that can be pushed or pulled to kind of guide, outcomes. All right. One of those things that can help or hurt a party in the case is the length of time it takes for one of the court's orders, once it's written and signed, to be entered in the clerk's office. As a general rule, or overwhelmingly, no one knows about the existence of the court order until it gets entered in the clerk's office, and it is therefore not operative. So, it's not enough to get like preferential justice in the form of a court order that says what you want it to say. It doesn't have any operative effect until you get it entered in the clerk's office. Okay? So that's a lever that can move one way or another. So if you have a ruling that's unfair, let's hypothesize that you have a group of lawyers before the Kenton Family Court that have a hookup, for lack of a better term, a good relationship, use your euphemism, with certain of the court staff members. Okay? And on account of that relationship, in whole or in part, you are able to get special access to justice, meaning heard more so or quicker than the average party down there. And you're able to get officially or unofficially special justice, kind of the outcome that you want, the findings of fact that you want, the relief that you want. Let's say you have that. Okay, well, if you're able to get special access to justice, special justice, in and of itself, that is not going to do anything for you or your client. You need to get that special justice operative, and that means getting the stuff in the clerk's office. Okay, so one way to mess with stuff is if the other side, despite the fact that they have a hookup with the judge's chambers and they get special preference, special access to justice, special justice, despite that, if there are orders that go on that are adverse to those people, well, one way to kind of screw with the system and help out that party is to delay the length of time it takes for those orders to become operative, to be entered in the clerk's office. Conversely, if you're able to get special justice in the form of court orders that say what you want to say, or even that you wrote in large measure, because the staff member at the court's chambers, in writing their opinion or order, just used, say, 1/3 of your proposed findings. Okay, things that you can submit to the court for their use, but which are intended, for the most part, not overwhelmingly for. You're not supposed to have the parties write the orders, really, as a general rule. You want to get that operative right away, so you want to get that in the clerk's office right away. So you can speed that up, right? Okay. In my cases, over a huge sample size, you have the equivalent of lightning striking the same tree on the same day, again and again and again. And here's the interesting part. And that tree is always falling on my house. Okay? It's really weird that lightning would strike this many times, but if it did, what are the chances that that tree is always going to land on my house? Statistically, it should fall the other way, land on the other house, the other side's house, if it really is just a lightning strike. Okay, So here's what we did. We took all of the orders in both of my cases, combined 126 orders, which are about evenly spread out between the two cases, the entire history of them, and we extrapolated from them the date that the court issued the order, which is on the face of the order, and we extrapolated the date they were entered, which is also on the face of the order. And then we took the full amount and we took an average, okay? And the average amount of time that it takes in the one case is 4.4, in the other case 4.1, meaning 4 days, if we round it, on average between the cases, from the time that the court has a signed written order, and the time that that is entered in the clerk of court's office, and then, known to the public, known to the parties, and becomes operative. Whatever justice is reflected in that order becomes effective, if you will. So the average is 4 days. Well, what you see here, and I'll just show you, you see some pink and some yellow, some other things, but here's pink and yellow, okay? Now, if you notice, there's way more pink than yellow. Now, what does yellow represent? Yellow represents the high-end outliers. These are instances in which the court was exceptionally, abnormally, unusually delayed in getting orders entered at the clerk's office, okay? So I believe the yellow reflect, anything over 3 times the average length, okay? Those tend to correlate with orders that were desired by my side or grant relief that are favorable to me, okay? And there's not many of those because there's not many of those, all right? Now, you'll notice the pink are all over the place. The pink represent instances where the period of time from the court's issuance of the order to that entry in the clerk's office was accelerated dramatically. In fact, the pink represent and are limited to instances where the court's order was issued and entered at the clerk's office either on the same day or the very next day. So 0 or 1 day delay. Given that the average on the whole is 4.5 days, that reflects a tremendous abnormality, okay? And that's within the context of my case. If you look at it in the universe of just how things operate down there generally, there are not many orders that are being issued and entered on the same day, just because there's a lot of orders being issued by the court, so it doesn't take them down to the clerk's office every day, presumably. But even if it does, there is definitely a delay at the clerk's office because it's getting orders from all over the place. And if they just go in the normal stack and are handled in the normal course, there's going to be some kind of delay, okay? And probably longer than 4 or 5 days. So if you have orders that are being signed and somehow entered virtually immediately, that is a big time outlier. That is lightning striking, statistically. Well, wouldn't you know it, in my cases, lightning has struck 34 out of 126 times. How about that? And all of the orders in which lightning has struck, meaning that there was that the justice that was dispensed, not favorable to me, that stuff got signed and entered, got entered right away. The tree fell on my house. So, this has been observed for a long period of time in my case, and it's fairly stark. But you can always explain away a single instance. And that's the case, too, from the other lawyers and other litigants who kind of see the same thing. But this is the full universe. These are the full statistics, and they do not lie. What conclusions can we draw from them? Well, this one. That's messed up, dude. I don't know who or when, I don't know when it became acceptable, culturally acceptable, or why. This idea that it is okay to tinker with the machinery of justice and to help one side. Now, I don't know if the attitude is, we're not hurting one side, Okay, we're just helping the other. But that kind of logic is recognized as being bunked by the scales of justice themselves. If you help one side, you hurt the other. You know, you disturb the equality. So it's, look, in a word, it's wrong. And here's my point. This is just one example. It's just one of scores of overwhelming circumstantial proof and a few instances of direct proof that, you know, special people get special treatment. And that ain't right. That ain't right. There's nothing more fundamentally contrary to the rule of law and to how a court is supposed to operate than that. And if we're treating people's lawyers differently, if we're giving special preferences to people's lawyers, we're giving those litigants special treatment. And that ain't right. And it's very, 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 very disturbing. I've never seen this in my career as a former federal prosecutor. I mean, really just as a lawyer, even absent that background. This is very offensive to the concept of justice. Now, do I have a self-interest in this? Yeah. I've got cases down there, and I need things to be decided on the facts and the law, and not and you know, the usual clique for people to not get special treatment. I don't want it. Frankly, if I were offered it, I would decline it. It's wrong. Okay? And that's the problem. That's the problem. So, this needs to be addressed. It's frustrating. In my case recently, the court issued a show cause order to another attorney that was involved in the case to come before the court and answer some questions because the court deemed a particular issue a serious issue. And it had with something that came up in the 3-hour hearing where we were virtually entirely dedicated to getting, you know, whether the other attorney was going to get paid for reasons that I contend then, I contend now. The court has no authority to grant, you know, to order the attorney to get paid. But my question is this: if that's a serious issue, if there's a serious issue about some statement in a filing that there was no report, and then 6 later it turned out there was a report. First of all, why that's hard to understand. People were confused. Okay, I have no idea. But if that's a serious issue, why isn't this a serious issue? Why isn't it a serious issue that you've got staff members who were caught red-handed having ex parte communications with opposing counsel in one of these cases to try and set up hearings with other judges when the judge in our case goes out of town after he enters orders that are favorable to my side, and they successfully get a within a day a hearing arranged with a different judge to try and undo these orders, and they get caught red-handed. Why aren't we issuing a show cause order about that? Why aren't we issuing a show cause order to talk about what, you know, the court has acknowledged at this point that, you know, in one of my cases, a 20-page opinion issues after 2.5 years of litigation, tons and tons of evidence, and in part denies one of those parties their fundamental constitutional rights, and the court acknowledges it never read their briefs. It never read their, I mean, if you're going to deprive somebody of their constitutional rights, don't we owe it to them to at least first hear them out? That didn't happen by the court's own acknowledgement in my cases, in at least one of them. Why don't we have a show cause order about that? Why don't we have a show cause order about the fact that you have court-appointed counselors and parties who are independent, who come before the court and who testify or want to testify or want to tell the court about how the guardian ad litem, who is a professional connection with certain staff members of the judge and the judge himself, about how this person has obstructed justice in the case, has done everything in his power to make sure that the court's order related to the expert's appointment does not get done. Why are we not having a show cause? Why are we not having show cause things about that? Okay. In fact, why is the court saying, I don't want to hear about that? Why does the court not want to hear about this? Why does the court deny evidentiary hearings about this stuff, but then we spend hours upon hours of time that plenty of other families with business in front of the Kenton Family Court who have legitimate issues that impact their family to decide? Why do we then take 3 hours to go motion by motion to determine whether, the preeminent face of the family court bar in Northern Kentucky, whether they get paid, particularly when, with all due respect, the law is absolutely plain that the court does not have the authority to grant that relief to begin with? Why aren't we talking about that? Where's the show cause orders there? I think these are fair questions. So, this is deeply troubling, and I put this in the public domain for a lot of reasons, but one of which is I feel a responsibility to. I am the unusual case that allows for the collection of this kind of sample size. Never before, almost certainly, and never in the future, almost certainly, would anybody have the opportunity to glean this data, to detect empirical disparate treatment from the objective statistics over such a sample size. We need courts that decide cases based on the rule of law. We need to do what's right by kids and make the courts about kids and not about attorneys getting paid. And this entire industry needs to be about doing what is best for the clients and the kids and not generating artificial conflict and having hookups down there at the judge's office and generating a revenue stream. And that's just the goddamn truth, okay? So, that's what I got to say. Thank you.